the legal profession. To the legal profession, it has significance because it is each and every one of us as a lawyer who is entrusted with the responsibility of defending the rights of people. Corruption is always against observance of the rights of the people. Corruption is characterized by dishonesty and illegal behavior. It brings out immoral standards of behavior, the willingness to use power, and in our case, judicial power or power as members of the legal profession to do dishonest or illegal things in return for money or to get an advantage. Usually that return is to suppress the rights of someone else. Lady Justice Irene, the IGG, has been giving figures here, and Uganda coming first and first and first. But we are not unique in this. In 2011, Transparency International carried out a global research, and they found that 46% globally of all judiciaries in the world were characterized with corruption within themselves. 1/3 of Europeans who were interviewed gave evidence that they had experienced corruption within their judiciaries. In Asia, it was the same thing. So corruption is a global problem, and we in Uganda, having come first and first and first, need to take serious steps so that we see how we can eradicate this vice amongst ourselves. Corruption may be in terms of bribes. It may be manifested by perceived judicial practices by judicial officers, showing partiality instead of impartiality, and lacking fairness. Corruption is also brought about by interference by third parties in the work of the court systems. So it is crucial that as courts of law and as members of the legal profession, we take steps as to how we can avoid this vice. Practitioners, legal practitioners, usually have a lot to do, either to stop the vice or to perpetuate it. Quite often, a practitioner comes and files pleadings, submissions. And one instance which is personal to me is where a practitioner came in with a client of his, and they said they were trying to file some supplementary submissions. And in those submissions, they said they have to hand it to the judge in person. And a person was passed on. And there was some envelope. Now, this lawyer was just joining the profession, and I said, "Sir, do you know what you are doing?" And he said, "No, I am just handing over this parcel on the instructions of my client." We took steps, and I hope that that lawyer learned some lessons. But this is what is happening every day. This is what is happening. And the burden and the duty is as much as to you, members of the profession. One, when you join the profession, please instill in yourself to abhor any act of practicing law in a dishonest way. And for us, in the judiciary, I have myself advocated that a judicial officer should be pointed out by those in the profession and members of the public, because they are the ones who can detect and see those core values in an individual. And then one should be invited to join the bench. It's a great responsibility, and I hope that the setup we have now is capable of meeting that responsibility. Identifying individuals. We may have academic qualifications, we may have other abilities, but do we have the capacity as individuals to abhor dishonesty, to stand up to being bribed, to stand up to being influenced by third parties, to stand up and say, yes, there is an advantage there which I can take, but the cause of justice demands that I make this particular decision. And you make it, even at the cost of losing that advantage. It's a great responsibility, and within the mechanisms of appointing people to the judiciary, of maintaining ourselves in the judiciary, that must be the guiding principle. Where we fail the judiciary. Where we fail, we encourage corruption, and where we fail, we let down the cause of justice. Corruption erodes the court's credibility as a fighter for the rights of others. If a judicial officer, and sometimes this is very, very obvious, a judgment is made by a judicial officer, the starting is logical, then you get to the middle, and then when you get to the conclusion, it has no bearing with the starting. Now, there must be something wrong. There must be something wrong. See? Now, if these are the judgments that we deliver, then the credibility of the courts is eroded. Most importantly, corruption erodes the function of the judiciary in democratic governance of upholding the rights of the citizens, particularly where those rights are being suppressed by the powerful organs of the state or of other powerful individuals. So corruption, if a court which is supposed to make a decision that is going to impact on members of the public, that court, through some corruptive influence, fails to make that decision, then that undermines proper governance of the country. And it leads to the violation of the rights of the ordinary members of the public. So what is the way forward? First and foremost is to ensure that there is a proper system within our constitutional setup of appointing judicial officers. And I am inviting members of the profession, the legislature, and the executive. There must be strict compliance with those provisions that must ensure that proper people come to the judiciary. For example, why doesn't the Judicial Service Commission publicly tell the world, or tell us in Uganda, whom the commission has recommended for appointment. That simple fact. If the Judicial Service Commission would come out and say, these are the ones we have recommended, then you will prevent your decision from being changed by some other third parties the moment it leaves your office. Because all of us would know that so and so is being appointed or is being forwarded to Parliament when there was no recommendation from the Judicial Service Commission. And we would be able to take action. But if everything is done secretly, then the names leave the Judicial Service Commission, and then they are substituted. You deprive us of the opportunity to take action. 2, Honorable Deputy Speaker, what prevents Parliament, when receiving the names from the executive, to also inquire from Judicial Service Commission, did you recommend this individual? What prevents? Then we know the Constitution is there, and then the proper people are is important. As the setup is now, the Chief Justice, as head of the judiciary, can forward a name for disciplinary action to the Judicial Service Commission. But what does the Chief Justice do if the Judicial Service Commission doesn't act? The Chief Justice is powerless. He's powerless. Or what can be done if instead of taking disciplinary action, another alternative is just taken? Lady Justice referred to a court clerk. You complain against a court clerk. You arrive in court at 9, the court clerk comes at 10, you complain. And then the next course of action is that this particular individual is now transferred, sometimes with promotion, to Minister of Agriculture. But what do you do? You see? What do you do? You see? And so the system is needs to be looked upon, and I think it is time we need it. Should the leader of the judiciary be left out of the Judicial Service Commission? It is historical how this provision came to be in the Constitution. And those who are aware, you know the individuals who were involved? Yes. And how this provision of excluding the Chief Justice, Deputy Chief Justice, principal judge from being a member of the Judicial Service Commission. But how do you discipline the judiciary when you have no finality in the process? We need to look at that. Then amongst ourselves, and this is lacking in Uganda, even in East Africa, I have said that we need to ensure norms of honesty, norms of fairness, norms of being fearless, norms of saying no to a powerful third party as a judicial officer, if the cause of justice so demands. But where do which body inculcates these norms into us? A number of us as judicial officers were appointed, and we never even got 1 week's induction. You are appointed, and the following week you begin work. There is no body within Uganda, either before or after appointment, that judicial officers can be taken to train and to have inculcated into themselves these judicial norms. And world bodies like the International Bar Association, Transparency International, the Judicial Integrity Group, the Bangalore Principles for Judicial Conduct of the Commonwealth countries have developed from within the profession what judicial independence requires. We need in Uganda to have that body where judicial officers, particularly those who are joining, can go and have these values instilled into them. Lastly, officers. Judiciary is supposed to be independent, but financial independence is not there. And this has implications. A study has been made in Malawi and Zambia, I think in 2011. There were presidential election petitions. And the powers that be, the government, whose leaders were the subject of the presidential election petitions, suddenly out of the blue increased the salaries and the remunerations and the allowances of judicial officers at the time the petitions were going to be heard. Now, what does this mean? It means that the one who controls the purse can starve the judiciary and indeed can strangle the judiciary when circumstances so demand? And can you also be very magnanimous with the judiciary at appropriate times? See? So it becomes extremely important, and judiciaries in Latin America, and now I think in Kenya, it becomes important that judiciaries, instead of being subjected to starvation or strangulation or magnanimity, that within the setup there is a particular portion of the budget that goes to the judiciary automatically. And this enhances the independence, but also helps the judicial officers not to be tempted with corruptive tendencies by those who control the purse. Now, we must also guard against undermining the independence of the judiciary. And I think this is the most testing aspect. As we fight against corruption, we must also guard against punishing, victimizing judicial officers who stand up, but then under the pretext of fighting corruption can become victims of the measures that are intended or are purportedly resorted to so as to fight corruption within the judiciary. We must have a balancing act, respect those judicial officers who are able to administer justice, while at the same time resorting to those means which are necessary to fight corruption within the judiciary. Let us always remember that it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. I thank you.
Ladies and gentlemen, another big round of applause for Justice Remi Kasule, past President, Uganda Law Society. And like I've said, I now invite Sise Kagaba to fire it up before we go into question and answer session. Welcome, Sise, with a big hand, please.
My lords, ladies and gentlemen, all protocol observed. Now, mine is going to be brief because I know most of the things have already been said. When we talk of judicial corruption, we need to appreciate the fact that it involves the entire cycle. It's not only about the judicial officers, because the public out there, and I'm speaking as a layperson, the public out there does not differentiate between a judicial officer or a court official. So if things like clerks, state attorney, lawyers, I mean, the ordinary person is going to look at you as a judicial officer. And it isn't surprising, obviously, when you look at the various reports that have been quoted by the Inspectorate of Government, public trust and confidence within the judiciary has gone down. And we need to ask ourselves that if the public fails to trust the temples of justice, then where are they going to run to? It's one of the things that we ought to reflect about. I mean, other than the reports coming out, but do we ever sit back and think? Because if I to get justice at a particular place, at least I'm going to be confident that when I run to a court of law, I'm going to get justice. But if people can't, ordinary Ugandans can't get justice when they go to courts of law, do we ever think of the repercussions? Well, the topic is how do we combat judicial corruption. So I'm just going to give briefly those issues that an ordinary person thinks about. I won't say much about the salaries because it has already been talked about. We cannot put or hide our heads in the sand, pretend this is not an issue. They are not an issue. They are an issue, and But they didn't know that it was a server. Then the IT people told them, no, that is a generator. The guys went away, and by the time they came back, the information had been erased. So do people actually know that they're huge servers that look like generators? Otherwise, if people don't know, you're going to investigate me, I'll tell you it is, well, I'll tell you it's a generator, you come back, I've removed the information. Then there's need of expeditious handling of complaints. Again, I'm not going to talk about this. We know members of the public have lodged complaints before the Judicial Service Commission. But again, we also appreciate the Judicial Service Commission because we know there's a commission, and at least probably there's something that they're trying to do in order to restore public confidence. I think for me that is a plus. What needs to be done? Promotions. Promotions within the judiciary should be tagged on integrity and performance. Now, it's very ironical that at times people are promoted even when they have cases or complaints against them. Really. If if an ordinary person has lodged a complaint against a particular judicial officer, and guess what? The person is transferred. After being transferred, the person is probably promoted. I mean, how do you expect people to respect the judiciary? So if you're promote people who don't have any complaints against them. Alternatively, expeditiously investigate these complaints, clear the people, then promote them. Then transparency in assignment of court cases. Are there guidelines or procedures for assignment of cases? Well, that's what an ordinary person thinks about how are these cases assigned to particular people. Then, again, because we also know that there are particular, well, I'll get to that. Then, bail, court bail, ensuring, you see, there's this thing of NC, non-cash. But we also know that non-cash turns out to be cash. Now, there's an ordinary person, because these are some of the complaints that we receive as an organization. You put NC, and guess what? People are made to pay cash. Do they know what NC is? If you want to combat corruption, I think it's one of those small, simple things that you can start with. Then, unnecessary delays. You need to combat unnecessary delays in cause listing. Because again, cause listing also at times, becomes an issue. How often, how fast are these cases cause listed? There's delay of trials, unnecessary adjournments, delay in giving judgments, failure to handle cases. These are things that ordinary Ugandans actually keep raising. Then improving file management is key. Whether a file is actually missing or it is intentionally missing. File management is going to be very key if you're going to combat corruption. There's an issue that the IG talked about, critical analysis of judgments. There ought to be, you see, if 80% of my judgments are overturned, either I'm incompetent or there's something wrong. And I think I liked what she said. We've heard of situations whereby along the way the judgment is aligned towards the plaintiff. It ends on the side of the defendant. Miracles are happening, the judgments are being given. And it is rather sad. Of course, we've had situations whereby a particular judicial officer gets money from the plaintiff and gets money from the defendant, and they tell this person, you know what, you're going to win this case. Of course, the plaintiff will win, and this judicial officer goes ahead and tells the defendant, these are the grounds of appeal. Guys, really? I mean, we hear these things and they're really sad. I mean, when you interact with ordinary Ugandans, it is sad at what is happening. And you see, the irony is, you hear certain things, others will even put a particular judicial officer on loudspeaker, and guys are asking for money. So it is really, at times it is so sad when you hear some of these things. Then, we need to make known the standards, of typing judgments. Again, some of the complaints we receive, people complain, are there standards of typing a judgment? How much is it? Are people actually paying what they should be paying, or they're paying more? So these are some of the things that a local person, an ordinary Ugandan, needs to know, because it's a bit of a challenge on their side. Then issues of unnecessary delays in processing matters before the registry. Then there's need to comply with standard caseload per judicial officer. There are situations whereby particular judicial officer A has over 80 files. And other officers are saying, give us some of those case files and we help you. The person says no. Then you ask yourself, what is really motivating this person to have all these very many case files and even refuse help from other people? Now that causes unnecessary delay. So, these things are known. It is sad, anyway. Then there's an issue, of course, of court clerks which needs to be addressed, because we also know that, again, there are situations whereby court clerks have held out on behalf of judicial officers. There are situations whereby the judge or magistrate doesn't actually know anything about this, but the court clerk is going to hold out, and people are going to give money to the court clerk. So it's one of the things that needs to be handled. Then, issue of transfers. A civil society raised these issues. If a person raises a complaint against a particular judicial officer, why do you continuously transfer them? You see, of course, we know that, someone is innocent until proven guilty. But you see, there's the whole issue that you're going to transfer this person to a remote area as a form of punishment. But transfers have never been a form of punishment. And again, we know, when you're transferring these people to remote areas, who is in those remote areas? These are the poor people, actually. You see, if it is naturally my trait of taking bribes from people. If you actually transfer me to a particular remote areas, you're not punishing me, but you're punishing those people where you're sending me. So I think for me the ideal would be, but well, in the event that it is not my trait, why don't you expeditiously handle this complaint and let the judicial officer off? Because we also know that there are people who may not know some of the dealings within the judiciary, and they may end up coming up with frivolous complaints against judicial officers. So if this is something that is happening, handle these cases quickly and sort out the issue. But the whole issue, because we've received cases whereby people are transferred from one area to another. The person took a bribe in court A, then the person is transferred to another court deep down in the village. And again, we get complaints about the same person, but this person is still asking for bribes. You're actually punishing those people who are down there. Then, well, lastly, again, we know there's a whole issue of lawyers conniving with judicial. That's why I said when talking of judicial corruption, not only looking at judicial officers, but they're also court officials where the lawyers fall. We know there's colluding, there's conniving between particular judicial officers and court officials. We know that there are particular, judges or magistrates that only deal with particular lawyers. You see, let me say I'm a judicial officer called A, and I always take bribes. What will I do? I have a certain lawyer friend of mine whom I deal with. So if I need money, all my other colleagues, all other lawyers will have to pass through that colleague of mine to get to me. It's complex, but you know some of these things. So it becomes very, interesting, whereby you have lawyers dealing with particular judicial officers to extort money from the members of the public. Then I think for me, there's need to have regular, what you call court open days. These court open days are going to ensure members of the public are going to come out, they're going to give feedback on issues relating to the court, and that can actually restore public confidence. Then there's need also to handle issues of absenteeism, late coming, especially in those rural or remote areas. I think for me it's very key. And for me, in conclusion, I appeal to both the bar and the bench to think about the actual cost of corruption on each one of us, especially on the justice system we are creating. You see, sometimes I think we think about corruption as numbers on a page, but the actual cost of lives and systems can be daunting. one day our kids, our relatives, will be victims of the pitfalls that we have created or we are establishing. We actually ought to seriously think about it and the actual repercussions. Thank you very much for listening to me.
Thank you very much, Sise. Please, another round of applause for Sise. She has actually assisted me with a bit of time because I'm running out of time. Ladies and gentlemen, it's now question and answer session. Remember, you are live on NTV. Can we have questions? And we'll get answers. I will begin with Commissioner Nora, then I will continue with the gentleman, then Bwenje, then I'll go to Hussein, then I'll go to my brother there, and then I'll go to Eli Karuhanga. In that order, that's the first batch. Let's fire up, ladies and gentlemen. Thank you. Can I have the microphones moving very quickly? We have very little time. The Chief Justice is supposed to be joining us for the next session. At your best behavior. Thank you.
Thank you, MC. Former President of the Uganda Law Society. I think that sounds better. My name is Nora Matovu, and I've had many things today. And today marks our 100 days since we were sworn in on the 6th of December as members of the Judicial Service Commission. And yesterday, we had the wrap-up of the 100 days since we started work. I'm not the official spokesperson of the Commission, but I want to also assure you as members of the legal profession that the Commission is definitely working, is setting a very different pace, and the appropriate person will definitely be able to communicate. But I wanted to say two things. First, we have reorganized the way we work in order to make our work more efficient. Because as you know, there is only one member of the Commission who is full-time. The rest of us are part-time. We have the work that we do. For example, I practice law and I teach at the Law Development Center. Secondly, to be able to do that, we've structured our work. So every month we meet twice as a full commission, and then the other committees also meet on the days they have set themselves. Then they report to the full commission. And that has fast-tracked our work in the last 100 days. Yesterday, I was able to deliver 122 cases that we have been able to plow through of complaints against different judicial officers, both on the higher bench and the lower bench. This is definitely contributing to reducing the backlog that we inherited. And that information, you may not be able to know all the details of who the complaint was against, but definitely it has been handled and handled effectively.
Thank you very much, Nora.
Yeah. That's why I said the official communication will come.
Okay, thank you. Next.
Yeah, thank you very much. Tmosije Chari is my name. I come all the way from Bushenyi. My question is, I appreciate the addresses of the heads of the different organs of justice. But if I remember very well, I think last year and in the previous years, the Law Council had promised us that they would be taking action in November, December, in the inspection of chambers. We are in April. Chambers are not are not inspected. To me, I don't know whether they have anything to tell us.
Thank you. Law Council, you will answer. Next, please. Mr. Bwenje, as we move. Over to him.
Thank you very much. My name is Francis Bwenje. I have practiced for over 3 decades. And I'm happy I see judges here, but I don't think any judge can say you ever came to corrupt me. No judge can ever say you came to corrupt me. But my experience at the bar is that what is called corruption of the judges is being exacerbated by clerks. The clerks are money collectors from our clients, and they claim to be taking money to judges. I don't think these judges receive the money. I think something must be done about clerks. In England, there is what we call legal executives. They created an association of clerks, law clerks, and they have got a disciplinary committee. Not merely public servants, but a sort of a professional association of clerks. If any clerk is involved in discipline, disciplinary action is taken. But here you cannot take disciplinary action unless you refer the matter to the Judicial Service Commission. Another experience I've seen, I think the judges are becoming victims of public. Because to me, my experience is that the lower cadres of the judicial officers are the people who demand. Now, I don't think a judge, once his sold or her sold, would say, you give me 100,000 or 200,000. But I think these lower cadres are badly paid. They don't have adequate salaries, and they always ask clerks to go and contact some of us lawyers. And I think my brother here, Charles, there is a case we took against, he took against a magistrate, and I defended the magistrate at the Judicial Service Commission. But we found that it was the clerks who are doing these funny jobs, but it was the clerks who are claiming that the magistrate were the ones sending them to collect the money. So I think something should be done about the system of clerks in our courts. Thank you very much.
Thank you very much. Over to you, Hussein.
Thank you, James, my lords and fellow colleagues. Mine is a comment which we shared with some of the colleagues as we were having lunch. My name is Hussein Kashirinji. I think it's not fair that you should have a Chief Justice as the head of the judiciary or a principal judge as the head of the High Court and has no powers over the officers he pretends over. So I would like to suggest, as we look to probably amending the Constitution, how about if the Chief Justice, for example, was given some power in the interim? For example, if the Chief Justice is satisfied that a prima facie case has been made against a judicial officer, he suspends that judicial officer as he forwards his name to the Judicial Service Commission. Because for a complaint to be forwarded to the Judicial Service Commission, I am sure that the Chief Justice does not merely act as a post, but has actually read through the petition or the complaint against the judge or judicial officer and has certified himself that there is a case that merits the intervention of the Judicial Service Commission. So if some powers to be given by the heads of those courts to exercise certain limited disciplinary procedures against those officers as the Judicial Service Commission attends to the complaint. Finally, on the same, we have had in the past. I don't want to gossip. Justice Chaudhry, I think retired now. Uganda Law Society made a complaint against that judge. It was investigated by the Judicial Service Commission, and they made a recommendation to the President. The President, for some reason, did not take action to appoint a tribunal. I'm sure he was advised by maybe one of us or a group of us not to do so. I don't want to get into the details. So in the event that you have a president who does not exercise that power to appoint a tribunal to investigate the judge, why don't we simply change the law and we let the Judicial Service Commission investigate, and once it is found that indeed the judge was involved in some professional misconduct, they take the action. If the judicial officer believes that, is not satisfied, you take other remedial measures, rather than for us to have this tripartite thing. The judge, the Chief Justice sends it to Judicial Service Commission to the President, then the tribunal, then back to the President, that. And while all that is taking place, the judge is working. He's working, and Justice Chodre retired and will always be called a judge and earn a pension. Thank you.
Thank you. All of us upstanding, the Chief Justice is walking in. All of us upstanding, please. Where is he going? Allow me to continue as if I think let me ask the President of the Uganda Law Society to just come and take over for a few minutes, just to welcome the Chief Justice.
Chief Justice, we want to welcome you to this discussion on judicial corruption. It's a panel discussion that is ongoing, and then thereafter we will shortly move on to launch the IBA Compact on Judicial Corruption, something that you have come to officially identify with. On behalf of Uganda Law Society, I welcome you. May I ask First President James Sebugenyi to continue with this panel discussion and finish? Yeah.
Thank you. That's the protocol, and that's how it's supposed to be. Thank you very much, Mr. President, and the Chief Justice. You're most welcome to join us. Ladies and gentlemen, we continue with the panel discussion. Hussein, can you summarize what you said in a minute?
My Lord, the Chief Justice, I made a comment just before you walked in, and probably you're the right person to make a comment. We were talking about judicial corruption, and I had suggested that, and you could share your experiences, that is it possible for us to change the law to give the head of the judiciary some interim powers, for example, to suspend a judge upon being certified that a prima facie case has been made against that judge, just as you forward that complaint to the Judicial Service Commission for handling.
Thank you very much. Can we continue? And as we agreed, very brief, because we have now gotten into the next session, and that's the reason why the Chief Justice is here. Very brief.
Thank you very much, Mr. Chairman. My name is Majera Nikazibwe. Mine is actually, it is connected to what was said, but this is something to do with the Inspectorate of Courts. My question is it possible to create a totally independent Inspectorate of Courts? Because we have had some experiences where an issue could come up and it goes to the Inspector of Courts. But then before going to the other very place where the problem came in, information is relayed there that a problem has arisen from that place, we are coming over. I'm looking at it this way. Is it possible to have a totally independent inspectorate so that these people just simply come in, go to the rural courts, find out what is going on? Because my other land friends were talking about the clerks and so on and so on. But there are also other people who are not even a part of the court system, but who hang around the courts and who actually get money. And some of them even say they know the judicial officers. It has become endemic, it has become a problem. So many members of the public are confused. Who is connected to the judicial officer at that very station? So can these inspectors just land there abruptly and then you see how they can wrap up and get those guys?
Thank you. Magellan, can you
secondly, it is an issue of administration of Justice Act.
Very kindly.
Most obliged.
One question.
Most obliged.
Thank you. Eli Karuhanga, I'll be coming down slowly as I'll batch you up as we go behind. Yes,
My
Eli?
Lord, the Chief Justice, members of the panel, Mr. President, I'm very happy as an elder to see how this hall is full of lawyers, most of them young, and how our country has now developed a very strong legal system that is backed by these crowds, and imagine there are many others who didn't come. So I'm very, very happy to see that. Two, on the judiciary, I would like to propose the following. Sir, the Chief Justice, you establish a scorecard for members of the judiciary. Those who sit on cases forever must file the cases they have handled in a month, in a quarter, in a year, and must provide the reasons why a certain file has been sat on endlessly. Those whose judgments have been appealed against and have been thrown out, if all my judgments, 10 of them have been overturned, what is my problem? And yet, I'm a permanent and pensionable judge. So that scorecard should give you some power to say, since 10 of the cases have been overturned, I am sending you back to the judicial service appointment, and in the meantime, you are no longer participating in this business until the judicial service brings you back, because since you have no power to do the work of the Judicial Service Commission, since in the CA, we decided to do that. Those are the two things. The other thing is an example I would like to give. One day,
a short one?
Yes, just a quick, and that's the end. One day, somebody opened a law firm when he was not a lawyer in worker's house and named his law firm Kampala Associated Advocates and put my name, Eric Arohanga, and all the partners on his letterheads and practiced law. So one day we received a truckload of files on the police vehicle to our office and said, do you know this business? I said, no. And this guy was arrested. Let me tell you, I went to court in Mukono so many times to prosecute that guy, but he would come and tell the judge that he's not feeling well, and the man said adjourned. We went so many times, me and Dr. Kami, until we were tired and we abandoned the business. He has now the man has opened again the business of Kampala Associated Advocates on the street, and he collects money and takes from. Now what do we do? And the judge the judicial officer was clearly not interested in pursuing this matter. Up to now, 4 years ago, imagine Kampala Associated Advocates, for which I am a member, we have abandoned the case. Because we have, now if we can abandon a case of our own interest, imagine what's going on in the public.
Thank you, Eli. Don't sort him out, please.
No. Thank you very much.
I want to go to the next level, and I will start with, can I see the hands up? I'll start with Justice Kwesiga. I'll go to Mr. Baku. I'll go to Ngaruye. I'll go to the lady. I'll go to Achelam, and then I'll go to Oponya. Am I right? And after that, I'll begin the next batch. But just bear with me. Can we be very brief? Because we now only have another 5 minutes of questions.
Right, thank you, MC. My Lord, the Chief Justice, my lords, ladies and gentlemen. For now, I'm talking as a member of the legal profession, not as a judge. But I would like to share with you a few things that would show you the dynamics of corruption, and to shift you a bit from having it appear as if it is a menace from the judiciary, but from the legal profession as a whole. I've been a judge for a shorter time than I have been an advocate, but for this short time I have come across 2 allegations of corruption where I was quite close, and I would like to share with you this. At one function like this one, I got information from senior members of the bar that one senior judge was corrupt and had taken bribes. I said I will not sleep with this. I confronted the judge. Worked backwards. Only to find it was a hoax. We called the members of the bar to come forward and give us facts so that we find out the source of the allegations. They melted away. At that time, the honorary president of the Law Society, Mr. James Sebgenyi, moved with me to the judge to apologize and put the matter in the right perspective. So where does it start from? Is it the judiciary? Is it the bar? Is it the society? The second one was directly concerning me. After handling a successful election petition, little did I know that something was going on. Unlike the situation where Justice Reme Kasure was handed over supplementary submissions by a young advocate, this was a senior member of the bar. I got it from the public, and the comment was this: Kwesiga kept quiet. Was he not grateful? I wrote it back. Grateful for what? Fortunately, this society is very small. We went to the husband of the petitioner, said, what is it that you did? Said, we gave the lawyer 30 million shillings because he said it was good token of appreciation. Do you see where it goes, members of the bar? We wrote it back. We called the lawyer through some people. I did not participate directly. We said, take back the money to the owners. So, is it the judiciary? Is it the bar? Is it all of us? We need to do soul search.
Thank you very much. The next ones, please.
Yeah, thank you very much. My name is Baku Raphael. I would like to appreciate the statement made by Justice Kasule. The only point I wanted to pick from there is his statement that there is no forum or body that trains and instills values such as integrity, judicial independence, ability to say no when it is required within the system here. I thought that was exactly the reason why the Judicial Studies Institute was established. Would that mean the institute is not playing its role? Would that mean it is not doing it properly? Thank you.
Thank you. Brief and to the point. Next, please.
Thank you very much, the MC. Our dear Chief Justice present, the justices of the High Court. Mine stems from the submissions of Lady Justice Mulyagonja that how often do we take on judgments as points of discussion as the legal profession? My question is, when this matter has gone appeal, so from the High Court to the Court of Appeal and the Supreme Court, unlike the time when as at university we would read a lot of dissenting opinions in judgments, where each judge would give their independent opinion and reach their decision. Presently, we have a lot of judgments coming in on appeal. One judge makes the judgment, and the others concur. There is beauty in dissenting opinions and leading judgments. Our dear justices, may we still embrace what we learned from. May we also embrace the right to a speedy trial, especially after the submissions are made and time frames are given for judgment. If a judgment took more than 6 months, more than 2 years to be delivered, is the community and the public we are serving seeing justice being done? May we practice justice as embedded in the laws that we practice, other than just delivering because we have a role. Thank you very much.
Thank you very much. But just by show of hands, how many would like to ask questions so I get an idea of how many people we have to deal with to manage time? Okay. Can I kindly request all those who have put up your hands, your questions and the discussions with your questions will be dealt with after the next session, which involves the Chief Justice and the President of Uganda Law Society. Very kindly, I appreciate if you could just defer, and we agree on that. Thank you very much. At this, Achelam, we want to go into the function of
Thank you very much, Mr. Past President. Distinguished lawyers, I think I came in at the wrong time. But it is better to be at the tail end of things and pick a few comments. Mr. Kashirinji asked the question, is it not possible to amend the Constitution to provide the head of the judiciary with powers to suspend a judge? I suppose that was the question. Of course it is possible to amend the Constitution. And I think it is high time we started looking at it seriously. Because from the time of the case of Justice Chaudhry, the Law Society may remember how we danced with the case of Justice Chaudhry. And the Chief Justice, Principal Judge were totally powerless to even stop him working. And even after the Judicial Service Commission recommended the appointment of a tribunal, there was nothing one could do with Justice Chaudhry. He even went to the Court of Appeal and got a very favorable judgment, which judgment I believe makes it very difficult in future to impeach a judge. So that's one. Two, yes, you have the Chief Justice as the chief in charge of administration of the judiciary, but without power to say, you stop for the time being, at least 6 months as I look at what you're doing. And the way the Constitution now is, to suspend a judge, it can only be done by the President. And the President can only do so after he has received and accepted the recommendation from either the Judicial Service Commission or the Cabinet and appointed a tribunal. It is only then that the Constitution says the President shall suspend a judge. Now, there are good reasons why those provisions were there, to ensure independence of the judges, not to feel frightened that they can be removed any time. But maybe experience is showing that we are abusing them. So yes, the people who have the power to amend the Constitution should seriously look at these things. The other aspect of the Constitution that I think should seriously be looked at, the Kenyans came and looked at our Constitution when they were making theirs. And they thought there are areas where we had put clogs for ourselves. If you appoint someone today who is 40 as a Deputy Chief Justice or Principal Judge, you are saddled with him until he reaches 65 or 70, whether he's competent or not. Unless you find grounds to remove him in accordance with Article 144. That's the Constitution as it is. So the Kenyans looked at, because I discussed this with the Attorney General and the former Chief Justice, they said that was a pitfall. So their Constitution, the judges at the Court of Appeal elect from among themselves the President of the Court of Appeal for 5 years. Then they can remove you if you don't perform, the judges themselves. So the country is not saddled with you until you reach 7 or 8 or whatever period it is. Same as a principal judge. A principal judge is elected by the judges of the High Court for a period of 5 years. You perform, the judges may re-elect you or get rid of you. Our Constitution, we have put ourselves there. You must find grounds to be able to remove this person for the next, if I am 40, you appoint me a Deputy Chief Justice or Chief Justice, you have 30 years to deal with me. So these are pitfalls I think we put in our Constitution, and maybe it is time to look at in the light of experiences of other people. Certainly it is a problem that someone can misbehave, and unless you have those grounds that are specified in the Constitution, then you may not touch him. And experience will be best teach us there. With regard to Inspectorate of Courts, yes, of course it is possible to appoint an Inspectorate of Courts on the lines maybe of an ombudsman, but you would have to think seriously about balancing the powers of such inspector as against the powers of the Judicial Service Commission. So I think you would have to look deeply at the constitutional provisions and so on. Right now, the Inspector of Courts is really an advisor to the Chief Justice, and his reports can then be taken to the Judicial Service Commission as to the current constitutional. Delayed judgments. Actually, we have 2 days ago received the report of the Case Backlog Eradication Committee, which has made some very interesting recommendations. One, we'll be coming up with the directions. All judgments that are pending, that have gone beyond the 60 days rule, we are going to have a cutoff date. They must be delivered by a date. Actually, the date proposed in the report is 30th April 2017. But of course, the report was written when they thought they would deliver it to me last month. But the point is, there will be that cutoff date. And if somebody does not live within that period, then that should invite possible sanctions, including a referral to the Judicial Service Commission. And that goes to what Honorable Karanga was asking. If you don't write a judgment for 2 years, are you competent? Because one of the grounds for removal is incompetence, but nobody has ever tested it. Nobody has ever gone to the Judicial Service Commission or the Cabinet to test what is competence. So if you sit on a judgment, 2 years, 3 years, if you give 10 judgments, as Honorable Karanga was saying, and all of them are ridiculed, not just upset, but ridiculed, are you still competent? I think we had one case here in the 70s, I think, of someone who was appointed an acting judge. We used to appoint judges as acting judges. Then if you didn't measure up, then you are not confirmed. I think there was one very senior academic, but who didn't make the grade, and he was discontinued. And another one who had been a chief magistrate also didn't make the grade and didn't go beyond. So I think there are things we can do, but we must look at the law. The law as it is now ties us, and you may have to deal with Katurebe for a long time. So the other day when I said I'm 67, I will retire in 3 years' time, I've seen people opening their eyes as if that was something from the sky. But if I'm 67 and the Constitution says you retire at 70, it's a truism, isn't it? But people are finding it strange that somebody can say I'm retiring. We have a problem in this country. Thank you very much.
Thank you very much, Honorable Chief Justice, for that response to some of the questions we've been discussing. Ladies and gentlemen, I'm kindly requesting all of you to give a round of applause for our panelists. Sise Kagaba, my Lord Justice Reme Kasule, my Lord Justice Irene Mujagoja, thank you very much for setting the ball rolling, and the Chief Justice coming in and wrapping it up very well as we adjourn the discussion to go into the next session. Another round of applause for the panelists as they come down.
I can prevent it. Okay.
Can I kindly arrange for some seats to be arranged for the judges and the panelists who are coming down?
Yes.
For Justice Kasule. Can I get a member of the Secretariat to guide Justice Kasule down to his seat? Ladies and gentlemen, continue at your best behavior. We are live on NTV and we are going to the next session. Ladies and gentlemen, it is now my humble duty to invite the Honorable Attorney General up to the podium, please. Mr. William Biarhanga, Honorable Attorney General, you are most welcome. I would also like to invite the DPP, Honorable Justice Mike Chibita. A hand of applause, please. And it is also my honor and duty by command of the President of the Uganda Law Society to invite the Honorable Deputy Speaker to join the podium. Ladies and gentlemen, we are now going into the next session as the Deputy Speaker comes up. Give him another hand, please. He's a member of the Uganda Law Society. Having had the panel fully constituted, I now have the duty and singular honor to invite the President of the Uganda Law Society, Mr. Francis Jimara, to address us and invite and conduct the next session. Thank you very much.
Thank you, James, past President. A round of applause for him. past leaders are always useful in Uganda Law Society. And I'll leave it at that. The Chief Justice, the Deputy Speaker of Parliament of Uganda, justices, judges, and judicial officers here, the learned Attorney General, the learned Director of Public Prosecutions, the Inspector General of Government, the Chairperson of the Law Council, again, past presidents of Uganda Law Society. May I say to the rest, all protocol observed. On my own behalf and on behalf of the council members who are here, and the council members can wave for recognition, the VP, the treasurer, wherever you are, yeah, on my behalf and their behalf, plus all of you, it's my pleasure to welcome you to this historic afternoon where we join Ghana as the second country in the world to embrace the International Bar Association initiative on judicial compact on corruption. This initiative is a build-up on the Bell the Cat project that was started under the leadership of past President James Sebugenyi. That's why we deemed it appropriate that he would chair this session. And it is a refresher of that project that was then timely, but again more timely even now. My Lord Chief Justice, just before you came in, this afternoon we had a very high-level panel discussing the topic of combating judicial corruption, the keys to effective judicial system. It is clear from the presentations made this afternoon by the panelists that unless we collectively act and join efforts to fight the vice of corruption, we will soon write ourselves into obscurity. The Uganda Law Society Council has made this year a special year of open engagement on this issue, and we have had several meetings with the lawyers on this issue. I have made it abundantly clear that we must not only be concerned, but we must all be involved in this fight against corruption in the judiciary. Even when we know that not all of us are engaged in this vice, let us not allow any one of us to mess the still waters of the legal profession. In this vein, I want to thank some of our members who have embraced the Bell the Cat project. It is true, Justice Kwesiga, like you've observed, not many of us have embraced, but I hope that after today, many of us will embrace the Bell the Cat project. Allow me, as the President, in my capacity, recognize the efforts of one of our members, Frank Kanduho, for coming out clearly and lodging a complaint in Judicial Service Commission. That is what the rule of law demands, that if one is aggrieved, you file the complaint where you can obtain an effective remedy. It is my prayer that the Judicial Service Commission will handle this complaint to conclusion. And why I mention Frank Kanduho is because of all of us can as well do these things. I am tired, as the President of Uganda Law Society, for people to come to me every day that so-and-so is corrupt, so-and-so is corrupt. And when I request that you file a complaint, then the lawyer begins trembling like a leaf, you know? He said, no, President, I just want you to take it up. But how do I take it up? It's not possible that the President of Uganda Law Society can act on rumors, on conjecture. A lawyer is called to defend the truth and justice at all times. And that calls upon you to be courageous. And if you can't file a complaint, please shut up, okay? Shut up and let the judiciary do its work. But if you have a complaint, and it is a genuine complaint, let's resolve today that let's test the institutions. I have personally talk to all the heads of these institutions, I'd say that the moment we get a complaint, genuine as it is, we will be able to lodge it without fear or favor, because we must make this country work for us. My Lord Chief Justice, as you are aware, corruption, much more than anything else, severely undermines the rule of law, causing citizens to lose faith in the ability of government to assist them. The only hope then for the citizen essentially is the judiciary. But if the judiciary is not corruption-free, then all the other efforts to prosecute and eliminate corruption cannot succeed. As one of the many response mechanisms to ensure that the judiciary regains and maintains its reputation as a true stalwart of justice, the International Bar Association has proposed the Anti-Corruption Compact Agreement as one of the initiatives at the global level to respond to corruption. This evening, my Lord Chief Justice, I want to thank you. I want to thank the Attorney General. I want to thank the DPP, and last but not least, thank the Speaker, because I reached out to the heads of institutions, because we discovered that issues to do with corruption cannot be fought in isolation. You need Parliament as an institution, you need the executive, and you need the judiciary. As you heard from the panelists, there are so many factors that cut across. So the invitation to the heads of this institution is to tie in what has been missing. And I am optimistic that by signing this compact, the Uganda Law Society, together with the judges and all judicial officers and the lawyers working in government, we will collectively this evening agree to become part of the army that will embark on a robust journey aimed at eradicating corruption from the judicial system. Additionally, the signing of this compact gives us an opportunity to reflect as well, to build upon our resolve and effort in, especially you, Chief Justice, it's building on your resolve to fight corruption in the judiciary. And I've discussed with you severally. I want to commend you for always involving and challenging the Law Society to take up this matter as a serious concern. So we are responding to your call that today, this evening, we are getting born again, if we are to use that term, that we will begin examining those things that make us sinners, and then we leave Entebbe when we are better, isn't it? Do I have your endorsement, members? Thank you. Make no mistake that we cannot lose hope in this fight against corruption, because when we lose hope, then the opportunity cost will win. And the opportunity cost for not fighting corruption is terrible. Let us keep our hope. It is difficult. I know many people may be saying, some people may be saying that this is just a piece of paper we are going to sign this afternoon. What will happen after? But the one thing that we must all keep, always in anything we do, is hope. Hope is very important, that soon we will respond and slay this dragon of judicial corruption. Let us be like the Tanzanian marathon runner, John Akwari, who while competing in the marathon in Mexico City in 1968, he cramped up due to the high altitude of the city. He fell badly, wounding his knee, and dislocated that joint, plus his shoulder hit hard against the pavement. He, however, continued running, finishing the race last among 57 competitors who completed the race. The winner of the marathon, Mamu from Ethiopia, finished in 2 hours 20 minutes. Akwari finished in 3 hours 25 minutes. When there were only a few thousand people left in the stadium and the sun had set, a television crew was sent out from the medal ceremony when word was received that there was one runner about to finish. As he finally crossed the finish line, a cheer came from the small crowd. When interviewed later and asked why he continued running, He said, and I quote, "My country did not send me 5,000 miles to start the race. They sent me 5,000 miles to finish the race." My Lord, the Chief Justice, the Deputy Speaker, the Attorney General, the DPP, justices here, judges, all judicial officers, lawyers, let's remember that our Almighty God, upon whose throne is founded on attributes of justice and almighty and righteousness, plus Ugandans from all corners of the world, of Uganda, have entrusted us with this noble profession and have sent us to finish this race of delivering justice. This calling alone should motivate all of us to fight corruption so that we enable people access nothing else from the courts but justice in her purest form. I once again thank all of you, our esteemed guests, for gracing this occasion. Your presence gives us hope that this evening we have renewed our resolve to combat corruption. Last but not least, I thank the IBA for initiating this compact. Both the current president, Mark Salk, the immediate past president, David Rifkin, and the executive director, Mark Ellis, have asked me to convey their apologies to your lordship. They would have loved to be here, but they have not been able to. This compact should open an opportunity for us to work together as stakeholders in the legal profession to deal with this issue. Thank you for listening to me this evening. God bless all of you, and may you be the fighters that this country needs for justice to truly come to this land. Thank you so much. My Lord Chief Justice, I am going to ask the head of the bar. The Attorney General is the head of the bar, and for a long time we've not had the head of the bar join us in our efforts. But now we have somebody from us who came from us. He's our friend. He has been practicing with us. So for the first time we feel like we have a head of the bar. We are no longer orphans. I want to invite Mr. William Byaruhanga to make his remarks and then invite the Chief Justice. Thereafter, we will go straight. The 5 people on the high table will lead us in signing the compact. Now, we'll put this compact on the website of Uganda Law Society. I'll also ask the Chief Justice that the judges who have signed, they put their list, that's the IBA recommendation, on the website so that it shows a new resolve to fight corruption. So I thank you, Mr. Byaruhanga. You are invited to address the gathering. Thank you very
much. My Lord, the Chief Justice, Honorable Bart Katurebe, the Right Honorable Deputy Speaker, Honorable Michael Chibita, officers who are here this afternoon, distinguished guests, ladies and gentlemen. Of course, the president of the Law Society, I was here yesterday, and every time I meet him, he keeps reminding me that in the past, they didn't have any interaction with the people who held the office of the Attorney General. Yesterday he was talking about building a bridge between the Uganda Law Society and the executive. I thought there always was a bridge, but he was telling me that we need to rebuild the bridge, or probably to add a few more pieces of timber. I would like to assure the President of the Law Society that as we leave Entebbe today, born again, as you suggested, let everybody be born again. Very few remarks from me, because the Chief Justice, I think addressing corruption, and we all know that corruption may be pervading the length and breadth of the profession, but particularly we are talking about corruption in the judiciary. And as Mr. Gimara has pointed out, I have myself held several meetings with the Chief Justice at which we have discussed the dragon of corruption in the judiciary. And I want to reiterate here in public that the executive, and the Chief Justice knows this, the executive is as keen as everybody else to slay the dragon of corruption. So I'd like to first thank the President of the Uganda Law Society for his remarks, very, very good remarks, Francis. I thank you very much for them. And I would like also to thank you for, I think you agree with me that his remarks were very, very good. And I would also like to thank you for launching this IBA Judicial Anti-Corruption Compact on this particular occasion. I also like to thank the Honorable Chief Justice and the Honorable Justices here present for also showing commitment to fight against corruption. It's a great pleasure, of course, to be at this launch with all these distinguished guests here and to witness the signing of the compact, as well as to be a part of this national fight against corruption, and especially so in our judiciary. The launch is important and timely because it offers us yet another opportunity to interact and agree on the basic tenets and guiding principles that will make our efforts and commitment to the Judicial Anti-Corruption Compact acceptable to all legal professions, all legal professionals present. I especially salute the judiciary for the tremendous efforts it's itself making to foster justice and accountability in our country. However, as we recognize these efforts, it is worth reminding ourselves of the persistent challenges that confront the justice system. The judiciary is a public institution whose job it is to provide fundamental checks on other institutions. Therefore, a fair and efficient judiciary must be the key to most anti-corruption initiatives. Speaking on behalf of my office and also on behalf of the executive, I just wish to reiterate that we are committed to the Judicial Anti-Corruption Compact, and we are proud to be associated with it. As I've already pointed out, the main actor this evening is going to be the Honorable Chief Justice, and it's on that note, sir, that I'd like to invite you to make your main remarks, and I thank all of you for listening to me, for God and our country.
The Right Honorable Deputy Speaker of Parliament, the Honorable Attorney General, the DPP, Mr. President, my brother judges, justices, members of the bar, ladies and gentlemen. I feel deeply honored to have been invited to be present when we are launching this compact. And I'm only too eager to sign it, if only to show my commitment to fighting corruption and to show how I hate and despise corruption and all that associate with it. But there are a few truths we must come to terms with as members of the bar and as Ugandans. When you open any newspaper today and listen to any radio station or TV, almost every headline or the second headline will be about some corruption in the public service, in the army, in churches, everywhere, every aspect of our society, there is corruption. Then somehow in that sea of corruption, we hope to find an immaculate island called judiciary that is free of corruption. That contradiction in terms we must address. Because, as I've said before, when I addressed you here, where do judges and judicial officers come from? You must have
This 10 years, keep to the court as a judge. So you come from the bar. So if the bar itself is corrupt, and by any chance the corrupt member of the bar finds himself on the bench as a judge, then you say you are fighting corruption. That's self-deception. Not long ago, Mr. President, I reported to you a case that had been reported to us at the meeting of the East African Judges and Magistrates Association by a professor from Makerere University Law School of a senior lawyer who went with one of the law students he was training on internship and carried 100 million shillings bag to corrupt a judge at the anti-corruption court. The judge dismissed them, and this professor was telling us at the conference center in Munyonyo, as they were leaving, this senior lawyer was teaching his student how stupid this judge is for refusing money. Now this is someone who is a senior lawyer, senior academic, training lawyers. So tomorrow, because of his high qualifications, if he becomes a judge of the Supreme Court or Chief Justice, what will he not do? So we must address some of these contradictions. And I'll speak from experience. In the last 2 years, I have received lots of complaints. And some of those complaints, I welcome them, but I insist. I don't want a complaint that is malicious, that is shopping for a judge. This is true. Some complaints are people who are making a lot of mud about the judge or about the magistrate. They want the Chief Justice to remove that judge or this magistrate from this case so that they get somebody more favorable. That is also an element of corruption. But where we have received a few cases where you can actually go and investigate, I have stood firm. Let me give you 2 examples very recently. Because if I gave you all the examples, it would say so long. But I will just give you two examples. I was in my office one evening, and a lawyer, one of you, called me and said, "You have a problem. Magistrate at this station is taking bribes." So I said, "Tell me the story." And he said, "This fellow has been hearing a case which pits some peasants against some well-to-do person. He has finished hearing the case. He is due to give a judgment on notice. So he called in these peasants and said, 'You people, actually you should win the case. But you have to give me 3 million shillings. Otherwise, I will give the case to the other party who is offering me 10 million. This is what this judge or lawyer told me. So, and I told him, fine. And those poor people are coming to him because they couldn't even raise the 3 million. So I said, let these people borrow the money, give it to them if you have to, lay a trap, inform the IGG or the police, let this man be arrested. And this was done. This was done. The IGG arrested this fellow, red-handed. He had just received 1.5 million. Can you imagine? Just 1.5 million. He was arrested, and the chief registrar called me after I think the next day, and said, "Chief magistrate at that station has been arrested." And I said, "Okay, fine. Now let's see what happens." A few days later, is the man in court? No, he felt very sick, he got a police bond. Days passed, what's happening? Well, he's being charged. Finally, to cut a long story short, that this fellow finally went to the IGG and confessed and said, "Yes, I did it. But please forgive me. If you charge me, it will ruin me. My name will be gone." So the IGG said, "Okay, I will excuse you this time, but resign. So this man offered to resign, and charges were dropped. Now, after offering to resign, and all this is no record, nothing in writing, Judicial Service Commission doesn't know, this fellow now uses his position within the to the Permanent Secretary, Ministry of Public Service, applying for early retirement. Not resignation, but early retirement. And the Permanent Secretary says, yes, your application is granted. But your terminal benefits will be withheld until you reach the retirement age. He waits a little longer, about 2 months. He then writes to the Permanent Secretary, now please, I'm starting a new life. You release my terminal benefits. And the Permanent Secretary says, okay, you may have your terminal benefits. And writes to the judiciary, because these days you have to get them from where you are working, writes to the judiciary to start calculating his terminal benefits. And we were at the annual judges conference. Up to that time, I didn't know what had gone on. It is, where is Honorable Justice Maria Gonja? She is the one who then told us that this fellow whom I caught and allowed to go to resign without charging him now has been allowed to retire with full benefits. And you remember Justice Maria Gonja, I just shot up and said, who allowed him to retire? Who allowed him to retire? And when I read the letter from the Permanent Secretary, Ministry of Public Service, the last paragraph said, thank you very much for your dedicated service. We have objected to this, and we have decided, at least for me, that the Judicial Service Commission should look at this. Much as the man has gone, if the retirement itself is valid, because that is another question, the way I know the Constitution, the man is appointed by the Judicial Service Commission, and the Constitution says when you are resigning, your resignation must be referred to the appointing authority. But anyway, that is another question. And it has been gratifying for the IGG to write and say she is willing to give the evidence that had been gathered against this fellow. So you have the evidence of the people who gathered the money, those poor peasants who collected the money, the people who were present when he was arrested, the arresting officers. They have even recordings of the conversation when he was asking for money. All that evidence was there to send this man away to jail. But the man got retirement with full benefits. That shows you the problem we have. What happened? Now, when the next time Transparency International, IGG write their reports about perception of corruption in the judiciary, what do those peasants think of the judiciary? Those people who reported, who saw him, whom he demanded money from and expected him to go to jail, but now see him, he's actually practicing law, he may even be here. So what do those people think of a judiciary? So next time when these reports come and talk of there's perception of wide-scale corruption in the judiciary, it is cases such as those. That's one case. Another case in West Nile, also recently, a magistrate in a traffic offense, again was reported said, okay, now you go and bring more. So these people are paying, but no receipt given. So eventually this was reported, and again the IGG investigated it, and the report of the IGG, which finally they have submitted to us, is say, yes, this fellow acted unprofessionally. He was collecting money, no receipts given, but we can't really prove that these people even paid money because they were not given receipts. Of course, when money for corruption cannot be proved because there are no receipts in corruption. But the IEG says, yes, we can prove that he stole 250,000, at least because they laid a trap and the money was numbered, so that one at least was found. Then the IGG says, but 250,000 is too little money because the prosecution will be more expensive, so we have decided not to prosecute him, but let disciplinary action be taken against him. So at least that one we hope the Judicial Service Commission will deal with. But you can see the difficulty. These are just 2 cases in the last 2 weeks. Now, as against those, I want now to give you the other side. Someone rings me and says, your number was given to me by so-and-so, that at least you talk to people. I said, fine, come. And it was a lady, she came. And says, our case has been in the court system for 7 years. People want to take my father's land and so on and so forth and so forth. So what has happened? Corruption, your magistrates. Your magistrates have been delaying this case and so on. So what happened? I looked at the documents. The first document on top was when the case had last come to court. And the lawyer had written to the magistrate that their lawyer had, there is a phrase you use, who had personal conduct of the case, could not come to court because he had to attend a meeting of the District Service Commission. The lawyer could not go to court because he had to attend District Service Commission. It was more important than attending court for his client. And it so happened that was the day the court was supposed to visit the local Synco. And the other parties were there with their witnesses. This lawyer refused to go there. The client himself turned up at the court and said, I'm not coming. So the magistrate dealt with the party that was there and then asked the parties, make your submissions. And these people now came to lodge a complaint with the Chief Justice. This magistrate, that party, they are collecting money in church, in their church every Sunday for this case, so they must be giving the money to the magistrate. I called for the fire. I even called the magistrate to come. First of all, what struck me is the magistrate being complained is a new magistrate. This is our first station. So the idea that this magistrate has been taking money for 7 years is not true. This is her first station. And I looked at the record. This person had changed lawyers several times. And one of the instances where again he was saying that Okay. So this fellow had come to court, finished his evidence, and then when the other side was supposed to give his evidence, another lawyer now turned up. I'm representing the other gentleman. I have documents to give to the court. And these were the magistrates, but these are photocopies. What you can do, you can bring them in for identification, but you need to record the witness to introduce them. The man says, no, you must accept my documents. So that became another complaint. So we discussed this. I called that person, come with a lawyer. We went through it with the lawyer, and they really saw the problem. Now they changed the tactic. We are now not comfortable with this magistrate. Give us another magistrate. And I've said no. Go and make that application in the court. So I could go on and on, but time is running off again. The point I'm making is this. Yes, we want to fight corruption. But this corruption is a hydra. It has got so many heads. And you touch someone, you get calls. This is our person, don't touch him. This is our friend. This is our party. This is all of those things. And then you say, we are marching forward in the fight against corruption. If we want to fight corruption, we must fight it. The people who take money to judges are us, the lawyers, the public. It takes a strong will to refuse some of these things. I remember a case we were hearing at the Supreme Court, which had huge money involved. And I got a call from a wife of one of the parties, "Hey, we want to see you." I said, this person has never rang me. "You want to see me about what?" "Don't worry, when we meet we shall tell you." I said, "No." "No." I said, "Tell me what it is you want to tell me, because that will determine for me whether I meet you at the office or at home or on the street." I said, no, you just give us a chance. Anyway, I never met those people. We decided that they had been blacklisted because I'm a very bad man. But those fights are going to be there, and we accept them. All we are saying, yes, the judiciary must be free of corruption, but it will take all of us to fight. Like that lawyer who called me and said, "You have a problem, this magistrate is going to take money." We must fight. I expect the Judicial Service Commission will take some action. We must report, but report factually. Report factually. I don't want a report which says, this person was actually not even fit to be appointed a judge. How he was appointed, we don't know. So what do you want me to do now with the Chief Justice? So those type of, I have a lot of them like this. So really, we are going to fight. If it means amending the laws, people are saying, let's the law. But if we can get we don't have to get many. I believe if we could get a few judicial officers, whether judges or magistrates or registrars, pick them and successfully prosecute them. For me, I don't mind, Madam IGG, whether it is 250,000 shillings, theft is theft. Whether you have taken, whether someone has taken 1 billion shillings or 1 million shillings or 50,000 shillings, which does not rightfully belong to him, it is theft. I was in the United States when I was Attorney General. I visited the IGG's office, and a person called Lesaspin, who had been Secretary for Agriculture, had just been acquitted, actually, because he was being charged criminally of offenses related to ethical conduct, that he was taking football coupons, tickets to go and see football matches with his girlfriend and so on, from a company that he was dealing with. And what came out about that trial is that the state had spent $17 million for that prosecution, and it had failed. But the point is, you don't steal money and get accused of misconduct and get away with it because you stole little. Because it will be difficult for us to establish how much must I steal to warrant a prosecution. Therefore, Mr. President, I welcome the Bail the Cat project. It was actually coined by the Uganda Law Society, I remember. I think when Bruce Cherere was still president, or one of them. But somehow it went dormant. Let us use it. Let us be brave. We will catch these people. Let us be brave. Because there is fear among the lawyers. If I report on this judge or this magistrate, next time I appear before him, what will he think? Well, you know, in Orinyankore they say, when you fear fire, well, how do you roast your meat? We want to eat good meat, which is justice. We want proper justice. And to get proper justice, we must fight the corrupt. Then you say, I fear to fight the corrupt because they might ban me. Well, then you don't eat. You don't get justice. So, Mr. President, thank you so much for this opportunity to make a few remarks. And I am ever ready. I stand with you. Anybody with a complaint, please bring it. We'll look at it. If it is something that we can forward it, we shall forward it. Thank you very much, ladies and gentlemen.
Another round of applause for the Chief Justice. Thank you. Chief Justice, I will now kindly invite you to come and lead in signing the compact, the IBA compact, as a commitment, a recommitment on the war against judicial Then thereafter, I'll ask the Deputy Speaker to follow, and the Attorney General and the DPP. Yeah. Just here. Yes. You can follow.
I'm ready to go as well.
So I want us to appreciate the Chief Justice and the team. Don't you feel re-energized this evening? We are signing off MTV. MTV, thank you so much for your sponsorship. We are going off now. We are signing off from MTV. Thank you for the great sponsorship.
The Timeline is brought to you by
MTN, everywhere you go.
And
DSTV, feel every moment.
Now, last week we did an episode on Blogging 101, the art of blogging. Now, a lot of you were sitting at home wondering, I'd like to know some of these bloggers, maybe even learn from them. Well, we heard you. Today on the show, we bring you the list of some of the top bloggers in the country. I am Oguchi Daudi, and welcome to The Timeline. Number 1, Ruth Aine. Now, Ruth Aine has vast experience in online and broadcast media. Her constant use of social media and blogs to communicate governance and society issues has seen her travel across the globe, representing Uganda and writing about development and political issues in regard to Africa and Uganda. She runs a personal blog at ruthaine.com and occasionally blogs for Deutsche Welle, among other platforms. Next on the list is Bernard Oloport, aka B-Wall Online. Now, he never seems to leave this list, from social media enthusiast to influencer to bigwig and now to blogger. Bernard is the guy running his blog at bwall.com, where he talks about pretty much everything using a hilarious choice of words and descriptions. A spoon on a table has never been as funny as when B-Wall describes it in written word. Now, we love that B-Wall has for years been consistent, and Ugandans are on their TL waiting every Monday for the latest blog post. Keep it up, B-Wall, keep it up. Next on the list is Nora Shirabo. She runs her blog at lookingfortheportofgold.com. Now, you can find everything from love to self-image to warm prose and poetry. Nora's blog is really, really homely, but we warn you, it's also really easy to catch feelings from her blog, so, tread carefully. Now, of course, if you're under the age of 18, this next blog is not for you. Parental guidance is advised when you're checking out Miss Narima's, aka Red Lipstick's blog, that is at marionette09.wordpress.com, because Red Lipstick is a literotica writer. She writes about love, she writes about relationships, and she writes about the art of sex. Now, Red has been at this for a little over 5 years now, and I said in a tweet thread how, while her blog is written with the intention to improve readers' intimate lives, more often than not, it has also put her life at risk. Please, just read her blog to see how her writing can improve your life, because she's not looking for you to improve her life. Get it? Now, how could we forget the old man of the clan, the bigwig, Bazanye? He's been at this for almost as long as some people have been in power. Well, not exactly, about 10 years, to be honest. But his blog is hilarious. You can go check it out at bazanye.com. He has everything from hilarious jabs at the news making the headlines to stuff that will just basically waste your time, but leave you with crack